b. to the legislature and government of each province in respect of all matters within the authority of the legislature of each province. Marginal note, exception 2. Notwithstanding subsection 1, section 15 shall not have effect until 3 years after this section comes into force. Marginal note, exception where express declaration. 33. 1. Parliament or the legislature of a province may expressly declare in an act of Parliament or of the legislature, as the case may be, that the act or a provision thereof shall operate notwithstanding a provision included in section 2 or section 7 to 15 of this charter. Marginal note, operation of exception 2. An act or a provision of an act in respect of which a declaration made under this section is in effect shall have such operation as it would have but for the provision of this charter referred to in the declaration. Marginal note, 5-year limitation. 3. A declaration made under subsection 1 shall cease to have effect 5 years after it comes into force, or on such earlier date as may be specified in the declaration. Marginal note, reenactment. 4. Parliament or the legislature of a province may reenact a declaration made under subsection 1. Marginal note, 5-year limitation. 5. Subsection 3 applies in respect of a reenactment made under subsection 4. Citation. Marginal note, citation. 34. This part may be cited as the Canadian Charter of Rights and Freedoms, Part 2, Rights of the Aboriginal Peoples of Canada. Marginal note, recognition of existing Aboriginal and treaty rights. 35. 1. The existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. Definition of Aboriginal peoples of Canada. 2. In this Act, Aboriginal peoples of Canada includes the Indian, Inuit, and Métis peoples of Canada. Marginal note, land claims agreements. 3. For greater certainty, in subsection 1, treaty rights includes rights that now exist by way of land claims agreements, or may be so acquired. Marginal note, Aboriginal and treaty rights are guaranteed equally to both sexes. 4. Notwithstanding any other provision of this Act, the Aboriginal and treaty rights referred to in subsection 1 are guaranteed equally to male and female persons. End note, 97. Marginal note, commitment to participation in Constitutional Conference. 35.1 The Government of Canada and the provincial governments are committed to the principle that, before any amendment is made to Class 24 of Section 91 of the Constitution Act 1867 to Section 25 of this Act, or to this part, a constitutional conference that includes in its agenda an item relating to the proposed amendment, composed of the Prime Minister of Canada and the First Ministers of the provinces, will be convened by the Prime Minister of Canada, and b. The Prime Minister of Canada will invite representatives of the Aboriginal peoples of Canada to participate in the discussions on that item. End note, 98. Part 3. Equalization and Regional Disparities. Marginal note, commitment to promote equal opportunities. 36. 1. Without altering the legislative authority of Parliament, or of the provincial legislatures, or the rights of any of them with respect to the exercise of their legislative authority, Parliament and the legislatures, together with the Government of Canada and the provincial governments, are committed to a. Promoting equal opportunities for the well-being of Canadians, b. Furthering economic development to reduce disparity in opportunities, and c. Providing essential public services of reasonable quality to all Canadians. Marginal note, commitment respecting public services. 2. Parliament and the Government of Canada are committed to the principle of making equalization payments to ensure that provincial governments have sufficient revenues to provide reasonably comparable levels of public services at reasonably comparable levels of taxation. End note, 99. Part 4. Constitutional Conference. 37. Repealed. End note, 100. Part 4.1. Constitutional Conferences. 37.1 Repealed. End note, 101. Part 5. Procedure for amending Constitution of Canada. End note, 102. Marginal note, General Procedure for amending Constitution of Canada. 38. 1. An amendment to the Constitution of Canada may be made by proclamation issued by the Governor-General, under the Great Seal of Canada, where so authorized by a. Resolutions of the Senate and House of Commons, and b. Resolutions of the legislative assemblies of at least 2/3 of the provinces that have, in the aggregate, according to the then latest general census, at least 50% of the population of all the provinces. Marginal note, majority of members. 2. An amendment made under subsection 1 that derogates from the legislative powers, the proprietary rights, or any other rights or privileges of the legislature or government of a province shall require a resolution supported by a majority of the members of each of the Senate, the House of Commons, and the legislative assemblies required under subsection 1. Marginal note, expression of dissent. 3. An amendment referred to in subsection 2 shall not have effect in a province the legislative assembly of which has expressed its dissent thereto by resolution supported by a majority of its members prior to the issue of the proclamation to which the amendment relates, unless that legislative assembly, subsequently, by resolution supported by a majority of its members, revokes its dissent and authorizes the amendment. Marginal note, revocation of dissent. 4. A resolution of dissent made for the purposes of subsection 3 may be revoked at any time, before or after the issue of the proclamation to which it relates. Marginal note, restriction on proclamation. 39. 1. A proclamation shall not be issued under subsection 38 1 before the expiration of 1 year from the adoption of the resolution initiating the amendment procedure thereunder, unless the legislative assembly of each province has previously adopted a resolution of assent or dissent. Marginal note, item 2. A proclamation shall not be issued under subsection 38 1 after the expiration of 3 years from the adoption of the resolution initiating the amendment procedure thereunder. Marginal note, compensation. 40. Where an amendment is made under subsection 38 1 that transfers provincial legislative powers relating to education or other cultural matters from provincial legislatures to Parliament, Canada shall provide reasonable compensation to any province to which the amendment does not apply. Marginal note, amendment by unanimous consent. 41. An amendment to the Constitution of Canada in relation to the following matters may be made by proclamation issued by the Governor-General, under the Great Seal of Canada only where authorized by resolutions of the Senate and House of Commons, and of the Legislative Assembly of each province. A. The office of the Queen, the Governor-General, and the Lieutenant Governor of a province. B. The right of a province to a number of members in the House of Commons not less than the number of senators, by which the province is entitled to be represented at the time this part comes into force. C. Subject to Section 43, the use of the English or the French language. D. The composition of the Supreme Court of Canada, and E. An amendment to this part. Marginal note, amendment by general procedure. 42. 1. An amendment to the Constitution of Canada in relation to the following matters may be made only in accordance with subsection 38 1. A. The principle of proportionate representation of the provinces in the House of Commons prescribed by the Constitution of Canada. B. The powers of the Senate and the method of selecting senators. C. The number of members by which a province is entitled to be represented in the Senate and the residence qualifications of senators. D. Subject to paragraph 41. D. The Supreme Court of Canada. E. The extension of existing provinces into the territories. And F. Notwithstanding any other law or practice, the establishment of new provinces. Marginal note, exception. 2. Subsections 38 to 4 do not apply in respect of amendments in relation to matters referred to in subsection 1. Marginal note, amendment of provisions relating to some, but not all provinces. 43. An amendment to the Constitution of Canada in relation to any provision that applies to one or more, but not all, provinces, including A. Any alteration to boundaries between provinces, and B. Any amendment to any provision that relates to the use of the English or the French language within a province, may be made by proclamation issued by the Governor-General, under the Great Seal of Canada only where so authorized by resolutions of the Senate and House of Commons, and of the Legislative Assembly of each province to which the amendment applies. Marginal note, amendments by Parliament. 44. Subject to Sections 41 and 42, Parliament may exclusively make laws amending the Constitution of Canada in relation to the Executive Government of Canada, or the Senate and House of Commons. Marginal note, amendments by provincial legislatures. 45. Subject to Section 41, the legislature of each province may exclusively make laws amending the Constitution of the province,